In today's video, I'm going to talk about a lot of the estate planning mistakes made by the rich and famous. For those of you that don't know me, my name is Zach Morris, and I'm the founder of Paces Ferry Wealth Advisors. And I want to talk to you about a lot of the things that we can learn from the people that are rich and famous, or were, and made some serious mistakes on their estate planning. So the first one I want to talk to you about is J. Howard Marshall. So J. Howard Marshall was an oil tycoon, and he married Anna Nicole Smith when she was only 26 years old and he was 89. They were married for 14 months, and then he died at the age of 90, leaving nothing to Anna Nicole Smith. One of Marshall's biggest mistakes was a lack of clarity and specificity around his intentions for his wife, Anna Nicole Smith. So this ambiguity led to a lot of prolonged battle for the estate between Marshall's family and Smith's family, and created a lot of emotional strain and financial strain on both families. So this could have been avoided by more clarity around his intention for the disposition of his estate. So in my opinion, he could have created a video that explained his intentions for his estate and had a letter from a certified doctor saying that he was in his right mind when he created that video. Now, all theatrics aside, Marshall could have done more to clarify the disposition of his estate. So speaking of theatrics, James Gandolfini, well known for his role as Tony Soprano in the hit show Sopranos, was no wise guy when it came to estate planning. Gandolfini died with a $70 million estate and did no complex estate planning. He had wills, but he didn't do any complex estate planning and ended up having to pay $30 million in estate taxes. So a little more estate planning could have allowed him to pass more money to his heirs. Another celebrity whose estate planning odds were not in their favor, Philip Seymour Hoffman, died with no complex estate planning either. So Hoffman had a will. However, when he created the will, he didn't want to leave everything to his kids because he didn't want to create trust fund kids. So he didn't create any trusts. And in his will, he left everything to his life partner, Mimi O'Donnell. Now, Hoffman never updated his will. So when he died, everything went outright to Mimi O'Donnell. Now, a couple things happen here. One is estate taxes were levied at the time of his passing because they weren't married. So there's something called the unlimited marital deduction, whereby you can pass as much money as you want. You could pass $200 million at your death to your spouse, and there's no estate taxes levied at the death of the first spouse. Since him and Mimi weren't married, then estate taxes were levied at the time of his death. So the remaining funds went to Mimi O'Donnell, and she had no legal obligation to save or put money away for the benefit of Hoffman's children. In addition to that, even if she were to disinherit herself, or a process called disclaiming the inheritance, it's possible that the inheritance would not have passed to Hoffman's children because there was nothing in the will that mentioned his lineal descendants. So another celebrity that actually did have a trust and did some complex estate planning, Michael Jackson, had a revocable living trust, but he never funded the trust. So Never Never Land never actually made it into the name of the trust. So this monkey business led to a lengthy and expensive probate process. And in addition to that, Michael Jackson never outlined all of his liabilities in his estate planning process. And so that led to even more difficulties. Now, moving on from the king of pop to the queen of soul, Aretha Franklin did not respect the estate planning laws, as she did not have a will that could be found at the time of her passing. So she died what's called intestate. Now, handwritten wills were discovered years later, and this is what's called a holographic will. So not to be confused with a hologram, a holographic will is a written will that must be signed by 2 witnesses in most states. So Arkansas requires 3 witnesses. New York, only members of the armed forces can actually utilize a holographic will. But in most states, you can have a handwritten will if it's signed by 2 witnesses. If you don't want the witness to actually have to show up to probate court at the time of your passing, then you more than likely also want to have the holographic will notarized. Now, Franklin's case underscores the importance of having documents that can actually be found. It's important to tell your loved ones where your documents might be. Now, The probate process for Franklin took years. The court actually appointed a niece to be the court-appointed representative to help with the settling of the estate, but through infighting in the family, the niece eventually resigned, and the courts had to appoint a court-appointed attorney to carry out the rest of the probate process. Now, last but not least, Jimi Hendrix, the guitar hero, joined the 27 Club with no estate documents whatsoever. So now the state court granted all of his assets to his father, even though he had a brother that he was very close with. His father then left all of the money to an adopted child through a second marriage. And Leon, Jimi Hendrix's brother, got nothing. Leon later had to sue his adopted stepsister, and he won after she countersued him back. So it created a lot of infighting in the family. But ultimately, Leon was able to benefit from some of his brother's estate. I hope you've enjoyed this video and you've learned something today. Please, if you'd like to, subscribe below and give us a thumbs up, and be on the lookout for more videos from this channel. Thank you.